Limitations on property rights. In many cases, property rights can be quite limited. The term encumbrance is used to refer to restrictions that limit real property rights. Government limitations. Local, state, and federal governments strictly regulate what property owners can do with their property. There are 4 basic government limitations, or public limitations, on what property owners can do with their real estate. Acronym PEAT. P. Police power. The right of the government to regulate private activity if it's in the public interest to do so. In real estate, police power usually refers to the local zoning ordinances and building codes. E. Eminent domain. The right of government to force the sale of privately owned property if it is in the public interest. Under the Fifth Amendment of the United States Constitution, the government must pay the property owner fair market value for the property. The legal process for taking the land by eminent domain is condemnation. If the government takes only a portion of the land by eminent domain, but not the whole parcel, the owner may receive severance damage. If the government action in an adjacent lot of land causes a diminishment of property value, a property owner can claim compensation under inverse condemnation. T. Taxes. Municipal property taxes. They are the primary source of revenue. They are the primary source of revenue for municipal governments, the local town or city. E. Escheat. The reversionary interest the state maintains in all privately owned property. If a property owner dies without a will or heirs, their property transfers to the government. Zoning ordinances. Zoning is a means of regulating and controlling land use. In Massachusetts, the zoning laws are found in Chapter 4OA, the Zoning Enabling Act. Towns often use comprehensive or master plans drafted by a planning commission to plan their future development. Zoning might include rules about use, heights, setbacks, lot size, and buffer zones. Okay. Use. The purposes for which property may be used. For example, residential property may be lived in, while commercial property may be used for businesses. Heights. Building heights. Setbacks. The distance from lot lines before the building is permitted. Lot size. The minimum permissive lot size. Buffer zones. Areas where you cannot build anything, used to ease transitions between zoning areas. For example, industrial to residential zoning. Properties can also take many forms under zoning. Single-family homes, detached homes, a property containing only one unit, multifamily homes, a property containing several different units, but that is not subdivided, condominiums, subdivided units contained within shared common areas, condominiums, subdivided units contained within shared common areas, cooperative, shared property owned by a company or corporation, mixed-use developments, properties containing multiple uses, for example, retail and residential condominiums, planned unit developments, mixed-use land developments that are often exempt from certain zoning regulations. There are 3 basic ways to bypass zoning: non-conforming use, a legal use that existed prior to the enactment of current zoning ordinances. Properties are grandfathered in, exempt, under zoning if a structure was legal when it was built, even if zoning has subsequently changed. Variance, special permission to do something otherwise forbidden by zoning rules. Conditional use permits or special use permits. Think of this as a limited variance. Conditional use permits, CUPs, allow commercial or residential use that would not otherwise be permitted in an area, with the caveat that you are restricted to a specific use case that is deemed to be in the public interest. For example, being the only supermarket in town. Towns usually use these permits instead of variances, allowing a residential property to be used commercially, which leads to converted use properties. While The process to receive a variance or conditional use permit is different in every municipality and is most often works like this. First, the property owner applies for building permits, approval to build something, with a zoning enforcement officer or building inspector to build whatever they want to build. The local officer or inspector will look at zoning rules and determine if the proposed structure is allowed. If the permits are approved, the property owner can build whatever it is that they applied to build, subject to local rules. On the other hand, if the permits are denied, or if the property owner knew that they would not be approved under existing zoning rules in the first place, the property owner can appeal the decision to the local zoning board of appeals, ZBA, by applying for a variance or conditional use permit. The ZBA will review the application. What, if any, hardship is imposed on the property owner by the local zoning rules, and any negative impact that the proposed building might have on the community. Neighbors will usually get the chance to comment on community impact during a public hearing, which can influence the ZBA's final decision. Again, while processes vary, the property owner must often show their enjoyment of the property is unreasonably impacted by local zoning rules, or that a variance or conditional use permit is necessary for their property to have worthwhile use. Often, a successful property owner will show that there is something unique about their property that requires the approval of a variance or conditional use permit so that they can fully enjoy their property rights. For example, a river that cuts through their property and is not present on other properties. Building codes. Building codes define basic requirements for construction without necessarily prescribing implementation. For example, you must have smoke detectors that meet the state standards, but not any specific brand. A certificate of occupancy shows that a building has been inspected and found to satisfy the building codes. Both stick-built homes, homes that were built on a property using traditional construction methods, and modular homes or factory-built homes, which are homes manufactured in pieces in a factory and then later assembled on a property, are required to meet the local building codes. Manufactured or mobile homes are sometimes held to a different building code standard, though they must also satisfy the relevant regulations. The Occupational Safety and Health Administration, OSHA, governs construction sites safely. Property taxes. That last sentence was just that OSHA governs construction site safety. Property taxes. Real estate property taxes are taxes paid to the town or city, the municipality, where a property is located. Property taxes are calculated against the assessed value or tax value of the property. This is known as the ad valorem tax. Think ad value. Every property subject to tax is listed on a municipal tax roll, and the total taxes collectible by the municipality will sometimes be referred to as the tax base of the municipality. Property taxes pay for local services like schools and trash pickup. Property taxes are paid in mills, dollars per $1,000 worth of value, expressed as a millage rate. Taxes are paid on a fiscal year running July 1st to June 30th and are due 11/1/51 or 8/1/11/21 and 5/1 if collected quarterly. Watch out for special assessments, which are special tax for any betterments to your property. Improvements paid for by public funds, such as town sewage hookups or sidewalks. Property owners are charged for special assessments in accordance to their frontage to the betterment over a period of years with interest. Special districts might also be used to levy additional property taxes. A special district is an area used to charge property owners in the district extra taxes for services that they personally benefit from, for example, a school or park. Math property taxes. What is the annual property tax on a $100,000 home that is assessed at 40% of its value in a town with a millage rate of $20 per $1,000. The equation for that would be the annual tax divided by the assessed value divided by 1,000 multiplied by the millage rate and then divided by the tax rate equal to 1, which is peculiar. So if we're applying that, it would be $10,000 times 0.4, which equals $40,000. Then you would take that $40,000 and divide it by 1,000, which gives you 40. And then you would take that number 40 and multiply it by 20, which means the person with the $100,000 home would be paying $800 in taxes, according to this. Okay. Private limitations. Private limitations or restrictions, also known as CC&Rs, are contractual limitations on ownership created by deed or separate agreement. There are two basic kinds. Covenants. Covenants restrict. Try that again. Covenants. Restrictions created by the developer of a subdivision, a property development, or planned unit development, a mixed-use property development, and recorded in the County Registry of Deeds. Covenants are binding on any property owners in the subdivision as long as they are deemed reasonable and within public interest. The developer or another owner may enforce the covenants by court action, but they must usually be enforced consistently and uniformly against all property owners in a subdivision to remain legal and enforceable. Deed restrictions. Deed restrictions are limitations written into a deed. They create a fee simple to feasible estate. If the restriction is violated, the grantor who wrote the restriction or the grantor's heir has the right to demand forfeiture of the title, meaning the ownership would revert back to the grantor that wrote the restriction. Conditions run with the land, meaning that they are binding on future owners of the property as well as the current owner. Conflicts between public and private limitations. If there is ever a conflict between a private restriction and a public zoning, the more restrictive rule wins. So if a private restriction limits homeowners to a 2.5-story building, but public zoning allows them up to 3 stories, the homeowner would be limited to 2.5 stories. Environmental limitations. Environmental law and restrictions are of concern to property owners, especially real estate developers, since they often limit what the developer may do with the property. Under NEPA, the National Environmental Policy Act, an environmental impact statement is required to determine what, if any, environmental impacts a development might have on an area and how a developer might handle those issues. Several pieces of environmental legislation impact real estate, including Comprehensive Environmental Response, Compensation and Liability Act of 1980, SURLA, commonly referred to as the Superfund Act. It was designed to clean up sites contaminated with hazardous substances to create liability for those who contaminated properties. The SURLA Act created the Agency for Toxic Substances and Disease Registry, ATSDR. The law allows the Environmental Protection Agency, EPA, to identify who is responsible for the contamination of sites and compel them to clean up the sites. If the responsible party cannot be found, the EPA can clean up the site using a special trust fund. A Superfund site assessment is often used to confirm or evaluate property contamination. Liability under SURLA generally runs with ownership or possession of land. So property owners or tenants not responsible for contamination, but in possession when the contamination is discovered, may still be held liable. This is called retroactive liability. In certain circumstances, the Superfund Amendments and Reauthorization Act, SARA, provides for innocent landowner status, which allows landowners who did not contaminate the property to avoid seeking liability. Typically, an environmental assessment will be done before purchase to determine if the owner needs to seek immunity protections under SARA. Leaking Underground Storage Tank Program LUST, sometimes called the UST Underground Storage Tank Program. LUST regulates underground fuel tank installation, maintenance, and spill prevention and monitoring. It is enforced and administered by the EPA. Certain tanks are exempt from regulations under LUST, including tanks under 110 gallons, tanks used for heating oil, and motor fuel tanks less than 1,100 gallons on residential farm properties. Mass Oil and Hazardous Materials Release, Prevention and Response Act, Chapter 21E. The Massachusetts Superfund Act regulates the transportation, storage, and disposal of oil and other hazardous waste in accordance with the Federal Comprehensive Environmental Response Compensation and Liability Act, CERCLA, Oil Pollution Act, and Clean Water Act. The Act authorizes the Department of Environmental Protection to take or arrange for responsive actions whenever it has reason to believe that oil or hazardous material has been released or that there is a threat of release of oil or hazardous material. The Act establishes strict liability, with exceptions, for releases or threats of release. The Act also creates an Office of Brownfield Revitalization within the Governor's Office and allows for the certification of lands as uncontaminated 21E certification. It also requires the certification of oil tanks to ensure that they are not leaking or otherwise contaminating the property. The Clean Water Act of 1972, CWA, regulates pollution of navigable and connected waters, established the goals of eliminating the release of high amounts of toxic substances into the water, eliminating water pollution, and ensuring that waters meet the standards necessary for human sports and recreation, limits and can prohibit the filling of wetlands and other property development near navigable waters, especially if the filling and development would substantially degrade the water quality. National Flood Insurance Program, NFIP, established by the Congress in 1968 as part of the National Flood Insurance Act and administered by the Federal Emergency Management Agency, FEMA, requires property owners in high-risk flood zones, think waterfront property, to purchase flood insurance if their community participates in the NFIP, National Flood Insurance Program, and if they have a federally backed mortgage. Massachusetts Wetlands Protection Act, a Massachusetts state law enforced by the Department of Environmental Protection, DEP, and local conservation commissions, the town and city environmental agencies that are tasked with protecting local natural resources. Wetlands are areas that are either permanently or seasonally wet, where the soil and the plant community have adapted to having that moisture. For example, riverbanks, marshes, etc. Wetlands are designated by the Massachusetts DEP, and not all wet areas are wetlands. The Act requires a buffer zone, an area where you cannot build anything, of 100 feet from any wetlands. The DEP or local conservation commission may permit certain minor changes after 50 feet, and may also permit certain changes within the buffer zone subject to DEP regulations, though typically no changes may be made to the wetland itself. The Wetlands Protection Act was amended in 1996 by the Massachusetts River Protection Act to specifically protect any riverfront areas that were not already designated as wetlands. Riverfront areas are the lands between the mean and high water line of a river or stream and 200 feet from that mean high water line, or 25 feet, in densely populated areas. The Act also provides $30 million for the acquisition and protection of riverfront lands by the state and for their administration and regulation by the local conservation commissions. While construction is not banned in these riverfront areas, developers must show that their proposed project will not impact the riverfront area and receive permission from the area's local conservation commission in order to build. Coastal Zone Management Act, CZMA, a federal law designated to protect coastal zones like the Gulf of Mexico or Long Island Sound. from the harmful effects of real estate development. It limits or completely eliminates development in those zones. Endangered Species Act of 1973. Designed to protect critically imperiled species from extinction as a consequence of economic growth and development untempered by adequate concern and conservation, may limit property use and development if the presence of an endangered species is discovered on the piece of property. Hazardous Material Transportation Act, HMTA. The HMTA regulates the removal, labeling, and transport of hazardous materials from a construction site. It is enforced by the Department of Transportation, DOT. LEED certification. Leadership in Energy and Environmental Design LEED is a suite of rating systems for the design, construction, operation, and maintenance of green buildings, homes, and neighborhoods. Developed by the U.S. Green Building Council, USGBC, in 1998, LEED is intended to help building owners and operators find and implement ways to be environmentally responsible and resource efficient. LEED certification also provides financial and permitting incentives for environmentally friendly construction sites. Under LEED, buildings are rated from 0 to 100 points, distributed across 5 major credit categories: sustainable sites, water efficiency, energy and atmosphere, materials and resources, and indoor environmental quality, plus an additional 6 points for innovation in design and an additional 4 points for regional priority. Buildings can qualify for 4 different levels of certification. Certified would be 40 to 49 points, silver would be 50 to 59 points, gold would be 60 to 79 points, and platinum would be 80 and above. Environmental vocabulary. There are a few additional environmental real estate terms that sometimes appear on the exam. Accreditation, an increase of property by the gradual natural action of wind or water, for example, the slow increase of a beach. Alluvial soil, soil deposited by wind, such as sand dunes or silt. Alluvium, an increase of land area along a shore deposited alluvium or by the recession of water. An increase of land area along a shore by deposited alluvium or by the recession of water. Alluvium being any clay, silt, sand, gravel, or similar detrital material, such as sand, rocks, or gravel, deposited by running water. Avulsion, the sudden separation of land from one property or its attachment to another, usually caused by flooding, a storm, or a change in the course of a river. Erosion, the process by which the surface of the earth is gradually worn away by natural actions, such as water, wind, and etc. Reliction, an increase of land by the sudden retreat of the sea, lake, river, or other body of water. Example, sudden decrease in the water table. That's reliction. Reliction. Other property right concerns. Easements. Easements are right of way across a neighboring property. The property with the right is dominant tenement. The one encumbered by the right is the subservient tenement. Easements are usually the rights of the property, not the property owner, and therefore run with the land. Transfer when ownership of the land transfers. Rights of ingress are rights of entrance, and rights of egress are rights of exit. There are several types of easements. Easement apparent, easements that involve 2 adjoining lots of land. One owner has a right of way across the other's property for some limited purpose. Easement appurtenant may be created in 4 ways. By deed. The easement is created in the deed when the property is sold. This can either come as an easement grant where the owner of the servient tenement grants the easement, or express reservation where the owner of the servient tenement reserves the right to use a portion of the property, usually when they own the dominant tenement as well. By implication, the seller implies an easement by sale of the property. This often occurs when the seller intended to create an easement but failed to do so. For example, if a property is sold with no legal access to the road but could be accessed by crossing the lands of the seller, it might create an implied easement. By necessity, if a property owner cannot legally access their property or it's landlocked, a court might grant an easement so that the owner can access their property. By prescription, an easement acquired by the open, notorious, continuous, hostile, and adverse use of the right of way for more than 20 years. For example, property owner A uses property owner B's path for 25 years. Property owner B never says anything about it, and they don't give owner A permission, asking them to stop or posting no trespassing signs. Owner A has been using the path openly, and they aren't sneaking by at night, notoriously, publicly, continuously. They didn't move it away in the middle of 25 years, and hostilely and adversely against the property's rights. In this situation, owner A could go to court and prove that they've been using the path for 25 years and be granted an easement by prescription by the court. Easement appurtenances are difficult to remove once they're in place. Generally, there are only two ways to remove them. By combining the two lots into one large lot, since an easement appurtenance requires two lots by definition, or if the purpose for which the easement was granted becomes impossible. For example, an easement was given for road access and there is no longer a road to access. Easement in gross. Personal easements granted in writing to someone who does not own an adjoining lot. For example, the seller of a piece of property writes into the deed that they have dock rights on the property. Easement in gross automatically extinguish when a person holding the right passes away. Licenses. Personal, revocable, and non-assignable permission to enter someone else's property for a particular purpose. For example, the homeowner gives a town 6-month license to step on 4 feet of their front lawn while they install a sidewalk in the neighborhood. Or a construction company receives a license to park their construction vehicles overnight in a nearby mall for 8 months while they work on a highway. Other examples include harvesting, timber licenses, fishing licenses, and even a ticket to enter Fenway Park could be considered a type of license. Encroachments. The intrusion of an improvement onto a neighboring property, for example, a misaligned fence. Failure to take action against encroachment may result in loss of land. Financial limitation liens. Financial limitations, or liens, are limitations on your ownership associated with debts or payment obligations. They can either be voluntary, taken on willingly, or involuntary, imposed on by a third party, and either statutory, put in place by laws, or judicial, put in place by court. Liens are usually paid according to first in time, first in right, meaning that the first lien put on the place is paid first, and so on. A general lien covers all property of the debtor, both real and personal. A specific lien covers the property identified by the lien, for example, a home. Voluntary liens. Voluntary liens make a piece of property collateral for some debt. They typically take two forms. Mortgage, used when borrowing money from a bank, usually for the purchase of real estate. The borrower or mortgager gives the mortgagee, which is usually the bank, the right to sell their home if they do not pay the loan evidenced in the note or IOU. The mortgage is a lien against the property in most states, though not all. Please see the financing section. Installment sales contract, conditional sales contract, contract by deed, or land contract, similar to rent to own. The seller or vendor enters into a contract with the buyer, which states that the buyer will make payments until the seller has been fully paid for the property. When the contract is fully paid, the buyer receives a deed transferring ownership of the property. Under the contract, the buyer holds what is called an equitable title or future right to acquire legal title ownership to the property. If the buyer defaults on the contract, usually by non-payment, the seller keeps any money the buyer has paid, and the buyer does not receive the title to the property. Involuntary liens. Involuntary liens are claims against the property that are imposed by some third party, usually the government or a court. Property tax liens. Claims against property for municipal property taxes. Property taxes represent a specific priority lien against real estate. This means that the taxes are paid first in the event of foreclosure, ahead of all other lien holders, persons or legal entities that have a lien against the property. If a property owner doesn't pay their taxes, the town or city of the property located will foreclose on the property and provide the purchaser with a bargain and sale deed or certificate of sale. In Massachusetts, property owners have a statutory right of redemption that is also called an equity or equitable right of redemption, or the right to pay their debt and regain ownership of their home that extends 6 months from the date of the sale at foreclosure. Land court has the right to extend this timeline. This means that after a home is sold at a tax foreclosure, the homeowner has up to 6 months to pay their unpaid taxes plus interest to get their property back. Federal tax liens. Liens placed against a person for unpaid income tax. They are generally liens and are used by the Internal Revenue Service, IRS, to recoup tax revenue. Estate tax liens are typically a type of federal tax lien used by the IRS to secure an estate taxes payments. Mechanics liens, a protection for contractors. They are allowed to place a lien against a property for work that they did and weren't paid for. This only applies to work done on real estate. Personal property is not eligible for a mechanics lien. A mechanics lien is an example of a cloud on title, or an issue with ownership that might create problems during a real estate sale, and of a statutory lien. Judgments. The final ruling by a court of law about who wins and who loses a court case often comes with an award of damages, monetary compensation for the harm suffered by the plaintiff, person bringing the suit. If the defendant, person being sued, can't pay the judgment, the court will often take their property, sell it in a sheriff's sale, and satisfy the plaintiff with the proceeds from the sale. Judgment liens are judicial liens. Attachments. A court order seizing property in order to satisfy a possible future judgment. A lien pendens is recorded to inform the public that the property is subject to litigation. Red flags that warrant investigation. Part of working in the best interest of your client is encouraging your client to look at any red flags that may impede on the property's right. It is best practice to follow these steps before having a client make an offer on a property. Check the property's deed and plat map at City Hall or via public record. Take time to review all the HOA, condo, or co-op documents for any restrictions. This is especially important if your client has a specific concern because different communities have different restrictions. Some restrictions might include breed or weight restrictions on dogs, the numbers of pets allowed, or even whether or not your client can put up a fence. Be sure to review the assessor's card for tax records such as special districts, special assessments, and recently paid taxes. If there was an assessor's card for tax records such as special districts, if there was a recent renovation, it is a good idea to look into any building permits that were pulled or left open. For easements or exclusive rights, for example, a roof deck, ask for supporting documentation if they're not in the deed. Local restrictions might also prevent your client from using their property as a short-term rental, so be sure to check those as well. It is also a good idea to check zoning and building regulations at City Hall if your client has a specific use for the property. Example, change use, add a garage or extension, etc. And finally, confirm whether the property is in a historic flood or wetland zone. As an agent, you should never state something as fact unless you have supporting documentation from a reliable source. Ideally, you should encourage your clients to complete their own research rather than relaying information, as this could lead to misrepresentation, and if need be, always defer to an attorney or source professional, for example, a tax assessor, flood insurance agent, etc. Okay, so that was limitations on property rights. Next one is transfer of property.